Well, welcome to Senate Judiciary on whatever date it is in August, August 25th of 2020. This is the beginning of our third session of the 2020 session. And we have a couple of bills that were passed by the House, and we're going to take them up this week. Our first bill is H578, an act relating to operators' license and privilege to operate suspensions and proof of financial responsibility. We have a number of witnesses here, and I want to announce that if anyone who's listening out there wants to testify on this bill or has a particular issue, they should contact Peggy Delaney at leg.state.vt.us. I think I got it right. And request to be placed on a future agenda. She and I will make a decision, but please let us know why your testimony would be relevant to the bill. So I realize that you're not able to join us on YouTube through the committee process, but we do want to be as open and normal as possible. With that said, I'm going to turn it over to Thea Dexter Cooper.
Just before we do, the correct date for today is August 26th, not the 25th, in case anybody wants to hear this later.
Oh, thank you for correcting me. This is Wednesday, August 26th. Thank you, Alice.
Yeah.
Under our Zoom, under our COVID-19 life, frequently I forget which day of the week it is. The only one that I know for sure is Thursday, because that's the day that the dog goes to doggy day camp. That's the only thing I have to remember anymore. So this is Wednesday, August 26th. I'm going to turn it over to Thea Dexter Cooper, Legislative Counsel, to walk us through the bill. And then we'll hear from several witnesses regarding why this bill is a good idea, bad idea, or whatever.
Good morning. So for the record,
may I ask a question first?
Yep.
Do we have this on our committee webpage?
Yes.
Okay.
I would assume.
Okay, great. Thank you.
So for the record, Anthea Dexter Cooper from the Office of Legislative Counsel. I don't appear before you guys very often. I don't know if you'd like me to put up a share screen as I do the walkthrough, or if you're going to have a separate device. We'll take my direction from you.
It's up to the committee. I've got a copy printed out of the bill, but committee would like to.
I prefer it not to be a shared screen, because you can't move around in the bill
Right.
at your own will.
Yep.
Okay, great. So I will open it on my second screen so that I can follow along as I'm talking about it.
Mm-hmm.
So the first section, section 1, is completely identical to language that was included as section 10 in the miscellaneous motor vehicle bill that passed at the end of the last section of your session. So whether you want to or not, this is now current law. It's adding, and this is in subdivision 4AB on that first page, that the Judicial Bureau hearing officer may waive the reinstatement fee required pursuant to 23 VSA section 675. This language used to be in Title 23, and then back in 2016, all the language for the suspensions was moved over to Title 4. And it is the belief of the DMV that this was inadvertently repealed, and the Judicial Bureau hearing officers lost the authority to waive this reinstatement fee. This would be giving them back that authority. It's set to a certain basis, which is the basis of the defendant's driving history, ability to pay, or service to the community, the collateral consequences of the violation, or the interests of justice. And the statutory reinstatement fee is $80. So that's what 675 subsection A provides. And again, this language is identical to section 10 in the miscellaneous motor vehicle bill. So this has already been enacted. You could pull the section out if you wanted to. you could make a different change, or you could leave it as is and it wouldn't be in conflict with what was enacted in early July. I can move to section 2 or pause if there are questions.
Mr. Chair?
Yep.
I don't know if you'd like us to have the walkthrough finished before we make comments?
No, I think we can make comments on the way through.
Okay, I would recommend pulling it out
Yep.
because we all voted for the change. So
Yeah. I'm assuming the House passed this before they passed the miscellaneous bill.
So H578 had both its second reading and its third reading on March 13th, the last day that you were in the building. The miscellaneous motor vehicle bill was still on the Senate calendar. It had had second reading, but not third reading at this point. So it passed without them having even seen the language in the miscellaneous motor vehicle bill.
Unless there's an objection, I would move, we could amend to take out section 1 and renumber the sections, since it's already law.
Okay,
Any objection? Good suggestion, Senator Baruth.
even a blind pig finds an acorn every now and then.
So section 2 is an amendment to 23 VSA section 801, which is when you need to have proof of financial responsibility, not to be confused with 23 VSA section 800, which says what financial responsibility an operator needs to have. So this is section 800 already says you need to have financial responsibility, insurance. Section 801 is in certain instances, which are laid out in subdivision A1, an individual would need to provide proof of that financial responsibility to the Commissioner of Motor Vehicles. This is also what's known as an SR22 certificate. And my understanding is that it can be very expensive to get an SR22 certificate, which is sort of the basis for why there might be a reason to make changes to when an SR22 would be required. The big policy change that's happening in section 2 is the repeal, and this is at the top of page 3, of one of the reasons why someone might need to have that SR22 certificate. And it's the repeal of subdivision F, which is if someone has been convicted of operating without financial responsibility, they then would need to prove going forward with the certificate that they have financial responsibility. So what this bill would do is eliminate the need to have that SR22 certificate. It wouldn't eliminate the need to have insurance, just the SR22 piece. The other policy change that's going on in this section is the repeal of subdivision G. I think it's a little confusing that it's in this proof of financial responsibility. This is why you would need to have an SR22 certificate section when it says in the middle of the language that's being proposed to be repealed that this is not to be proved with an SR22 certificate. So in current law, it says that if someone is issued a ticket or a citation for a moving violation and they already have 5 points, at the time of the issuance of that ticket or citation, they would need to prove that they have insurance. My understanding, and I think you're going to be hearing from people from the Department of Motor Vehicles, is this is not actually current practice and that this proof is not required. So the repeal of this subdivision could very well be just making codified law consistent with current practice. And then the change.
How can I ask a question?
Mhm.
How can current practice not be comporting with current law? I would think an agency of state government would need to follow the law, whether that's good law or bad law,
Yes.
and then repeal it. So it's hard for me to understand how, I'm glad the Department of Motor Vehicles, I have a tremendous respect for the Department of Motor Vehicles, don't get me wrong, but I'm surprised to hear that they're not following current law.
Could I,
How can they do that?
can I just say something there? I think
I
that
would
happens. in
prefer
a
that the
lot-
witness answers the question.
Oh, okay. I wasn't going to answer the question. I was just going to comment that it happens in lots of cases. And we just saw it in 120, S-124, when we changed the way the Commissioner of Public Safety is appointed. In the law, it says that they're appointed for 6 years and they can't be removed. And it's not at the discretion of the governor, but that doesn't happen. We know that. So I think practice is often in conflict with law.
But oh, then why should the public follow the law?
So to answer the question, Senator White gave an excellent answer. I think what happened here was that at some point, a form sort of got changed. The way I read this, it sounds like there should be a certificate that's issued with the citation that needs to be returned. And it is something that at some point stopped happening. It should be happening, but this bill would make the policy change to say, no longer do we want someone to need to fill out this certificate if they are issued a citation or a ticket and they have more than 5 points already.
Well, it's troubling that the administration can follow the laws that they want to follow and not have to follow the ones that they don't want to follow. And rather than seeking a change in those laws. So I'm glad that we're changing this law to comport with current practice, but it seems to me that the administration could come forward in all of these cases. There may have been a good reason why the Commissioner of Public Safety was appointed for 6 years and not be subject to be similar to the Defender General. So it's not subject to the political whims. So that's just a side comment, not your fault. But maybe we need a committee, a special committee on administration following the law or something like that. I'll think of a great name for it.
So then the last change in section 2 is just because this would be repealing subsection G. In subsection H, it is just making the language consistent there. So it's just a small technical change.
Great.
End of section 2. Section 3 would be a change to how long this proof of financial responsibility needs to be carried. So under current law, for all of the reasons that you would need to have an SR 22, you need to have it for 3 years from the accident, conviction, or judgment giving rise to the obligation, or 3 years from a suspension if there's a suspension with it. This would be changing it so that the base is 1 year. So dropping it by 2 years, that would be in subsection A. And then in the top of page 5 in subsection B, it would be keeping it at 3 years in some instances. And the instances where it would stay at 3 years is a conviction for careless and negligent operation of a motor vehicle resulting in death, reckless driving of a motor vehicle resulting in death, and a second or subsequent DUI. So it would be 1 year that you would need to have the SR 22 for everything that's required to have an SR 22. And then it would stay at 3 years for those other 3 instances. And then subsection C, and you'll see this language a lot, just to be very clear, just because you don't need to have an SR 22 doesn't mean that you can get away without having insurance for your vehicle. So this is current law, it's just being its own subsection. And you'll see the language later on in section 4 as well.
When we get to Jamie Feenan, I guess my question is, how does the insurance company, insurance industry deal with this? Isn't it going to, frankly, if somebody has a DUI, there's a tremendous cost to insurance, no matter what we do. And will those rates go up because they're not required to have the SR 22 after a year? So that would be a question coming up later if you want to think about it, Jamie. But first thing that pops to my mind is the insurance industry, even though we've done away with the requirement for the 3 years, will reset the cost of insurance, because obviously they may consider these poor risks. I know that I know people who've had a number of accidents who are older Vermonters their insurance goes up based upon that accident history, even though they're not serious accidents, but they're minor. But their insurance, goes up. So, curious about that. But that's helpful to know that you'd still be required if you have one of these other events. Any other questions about section 3?
Yep. Can I ask
Senator
a-
White, I think.
So Anthea, if you have an accident and then so you have to have this for 3 years, right? Or 1 year if it gets changed. But what if you don't get your license back for 5 years? Do you then have to start over and have the SR 22 for 3 years?
So the language in the current law that says, and this would be duplicated for the 1-year section and the 3-year section, in the event that a suspension or revocation resulted from the conviction giving rise to the obligation to have the SR 22, an operator shall not be relieved of the obligation to have that SR 22 until 3 years under current law, and it would be the change to 1 year or 3 years after his or her reinstatement eligibility date. So it would be 3 years after the reinstatement or 1 year after the reinstatement.
Even if you didn't get, somebody decided they didn't care if they had a license and then 5 years later they decided to get it back, they'd have to then have SR 22 for, even though it's been now 8 years since the accident.
Yeah, that's my understanding.
Whoa, okay.
That's an interesting reading of it, because if their license was suspended for it, let's say it's operation reckless driving and motor DUI, first DUI, the license is suspended for a period of time. Is it 90 days?
It's through the civil suspension piece that is one of the times that it could be suspended for. It varies.
So they would need to pick up on that whole suspension period doesn't count towards the number of years. That's what I'm hearing.
Right, because it measures from 2 different starting points. So it could measure 3 years from the point when the obligation commenced, or if there's a suspension, it's 3 years from the end of the suspension.
So
Right.
what if it's suspended for 90 days and then they just decide they're living in a cabin in the woods and they don't even really need a car or a license or anything for the next 2 years, but they still have to start at that 2-year point when they get their for, whoa, that doesn't make any sense at all. I mean, it could be years down the road when somebody, anyway, okay.
Thank you.
Do you see Mike Smith over there waving his hand?
Mike,
No,
did you
very-
want to shed some light onto this problem?
Yes, please. I didn't, in Teams, there's a button I can click to raise my hands. I didn't know how to get
Oh.
your attention, so.
Well, I suppose, I don't know.
But for the record, Michael Smith, Director of Operations for the Department of Motor Vehicles. So in regards to the statutory language talks about 1 year or 3 years after the reinstatement eligibility date. So let's take a DUI 1 or a DUI number 2, for example. Those are term suspensions. So at the end of 18 months, you are eligible for reinstatement. Your 3-year period in current law would start as of that eligibility date. It has nothing to do with whether you get reinstated or not. Now, let's move to a DUI number 3. A DUI number 3 or more is technically a life suspension. So on a life suspension, there is no reinstatement eligibility date per se. So you get your reinstatement eligibility date on a lifetime suspension after proving total abstinence. So in that case, the 3 years would start at the time of reinstatement. Does that make sense?
So it starts when you're eligible for reinstatement, not when you actually,
Absolutely,
apply for it.
unless
Okay.
it's the 3-year or unless it's the DUI number 3.
Yeah.
Yep.
And eligibility is in there. I'm sorry if I skipped over that.
Thank you.
Thank you. Can we go to section 4?
Sure. So section 4 is all session law, and it deals with how people who currently need to have an SR 22 would be dealt with if the law had existed the way that this bill would make it before they were required to get the SR 22, what should happen? Should they need to carry it for 3 years, even though it was for not having proof of financial response, not having insurance? Or should it, as soon as the bill passes, they don't have to have their SR 22 anymore, because we're saying with this change in the law, we don't think that your action should have triggered the need to have an SR 22. So what this says is sort of the two instances. Either you are someone who currently has an SR 22 and you wouldn't need to have one under the new law. The obligation to have that SR 22 will be relieved as soon as practicable, but not later than January 1, 2021. And again, this was passed back in March by the House, so maybe the timeline needs to change a little bit. And then if you're someone who is currently carrying an SR 22 that needs to be carried for 3 years from either of those counting points, but under the change in the law, you'd only need to have it for 1 year, and you've had it for 1 year or more, what should happen? Same deal, you should be relieved of the obligation as soon as practicable, not later than January 1 of 2021. So it's like the reverse of grandfathering in people. You're ungrandfathering them in from the SR 22 requirement and saying we're going to treat you under the law as we're passing it retroactively of sorts.
Okay.
And then you're going to see that same language in subsection C, just to be clear, just because you're relieved of your obligation to have the SR 22, the proof of financial responsibility, doesn't mean you don't need to have insurance under 23 VSA section 800.
Okay.
And then the final section is the effective date section. This was expected to have been in a session that ended before July 1. The reason why it wasn't on passage was to give a little bit of ramp up time so you don't suddenly have insurance law changing. So probably you're going to want to either make this at some point in the future or make it on passage if you move forward, if that's something that would be possible from an.
Well, I would prefer to hear from the Department of Motor Vehicles and other witnesses on what they think are reasonable dates, both for the effective date and the other section we just talked about, where we have the date of January 1, 2021, not later than in section 4A, the January 1, 21, if that's realistic. And if this effective date is realistic.
Well,
It's not realistic because obviously it needs to change, but change to what?
Right.
October 1st, January 1st, December 1st, whatever. So we look forward to hearing on those changes. Our next witness, are there any other questions for Anthea?
Anthea.
Thank you so much. Did I mispronounce?
You
Neil?
got it.
Thank
And
you.
the only person who cares about the pronunciation is my mom, and she's not around to hear however people say it.
Okay, well, thank you. Neil, if you could join us now. Are you there?
Yes.
Oh, Neil, thank you. The only reason you're on the agenda is because you were on the House agenda, so whatever you told them, we'd love to hear. The
Well, as I
impact-
recall, yes, for the record, Neil Schickner, Joint Fiscal Office. As I recall, in the House, the only issue in this bill was raised as having a potential impact on the revenues of the state was the authority to the judiciary to grant a waiver from the reinstatement fee. And the answer to that was, it's anybody's guess because you have a broad grant of discretion and no basis for projecting how that discretion might be exercised. But in terms of the latest data I have on the number of reinstatements, a good guess would be 100 to 120,000 at the worst.
Any questions for Neil? Thanks so much, Neil. Since that was part of section 1 and would not be part of our bill, I guess that would be mute now for us because it's already passed, correct? Okay. I'm going to go to Mike Smith, if we don't mind right now. Hearing no questions for Neil. Thank you, Neil. Mike, from the administration point of view on this bill, any comments, and then maybe on the effect on the dates that we just discussed?
So I think this version of the bill is a lot more palatable for the department than the prior version. So really the only comments that I have now that we've clarified when the eligibility date kicks in is really in regards to the effective and the implementation dates. So I think you hit the nail on the head when you said that, you know, the dates do need to change. I would like to ask for, you know, an extension on the January 1st, 2021 deadline to have this done. Clearly, we will do this as soon as we can. With all of the stuff going on with COVID and reopening and trying to come up with new services for residents of Vermont, I'm just concerned that I may not be able to, or the department may not be able to clean these records up by January 1st, 2021. So,
Yep.
You know, and so I would ask for as much time as you would give me. Part of me wants to say July 1st, 2021. I don't know if that's too far out for the committee. Any extension would be greatly appreciated.
I'm concerned about going that far out,
Okay.
but we have no idea what next spring is going to look like.
I know. So.
That's the concern I have. So I was going to say April 1, and then if that needed to be extended, you have the January session to come back and say, look, this just isn't going to cut it. We need to go to June 30th.
So I was prepared to ask for July 1st, and if you said no, I was prepared to say March 1st, so I'd be happy to take April 1st, if you would be willing to do that.
Well, I'm looking at it on a quarterly basis, so why don't, unless there's an objection from the committee, why don't we go to April 1st?
Okay.
With an understanding that if, you know, if we don't get some relief from, you know, and start to get back to the new normal, we may need to revisit it again in January.
Okay. Thank you.
And the effective date of the bill, would January 1 be okay, or?
I think so, yes, because really I can't start cleaning the records until it's effective. You know, and our plan would be to advise the programmers of what they're going to need to do and start working on that, but it'd be in between other projects. So I think January 1st would be a perfect date.
2021. Got it. Any other comments from the committee?
I do not. Thank you.
Thanks, Mike. Appreciate it. Thank you very much. By the way, seriously, thank you and all that DMV is doing to try to help us get through this in these difficult times. And I know we down in Bennington County are frequently a pain in the neck because we don't have our shop open, but I've been appreciative of the way you've responded to our constituent concerns.
We are here to help, and we're trying to do everything we can. And as the commissioner said yesterday at the press release, you know, once we get the first 3 offices open, we do endeavor to get the other offices open and get the services out to the public.
Okay, our next witness is Willa Farrell, Director of Court Diversion and Pretrial Services. Willa, welcome to the 3rd session of the legislature for 2020.
Senator Sears. This is Willa Farrell from the Attorney General's office, and I just want to start by saying that I had a long-standing appointment to have an airbag recall fixed in my car, so I'm sitting outside, and I'm not sure how noisy this is, but if necessary, I can put my mask on and go inside if that's easier.
You're fine.
Okay, thank you, sir. I'm also trying to make my video come on and having struggles. So I'll just speak briefly. As many of the senators know, court diversion operates a DLS program. We work with a lot of people who are trying to regain their driver's license. The main obstacle that I hear for people to obtain their license these days is paying for SR22 insurance. The legislature has implemented various methods for people to pay their debt to the state over time and to avail themselves of requesting of the Judicial Bureau reduction in what they owe. The SR22 insurance remains a significant barrier because of both the cost and the length of time that it is required. So the change from 3 years to 1 for a number of violations would be a benefit to many people. I don't have data, I have anecdotes I could share. I can also submit a summary of stories I gathered from programs that are a written testimony I can submit to the committee.
That would be.
Okay, I can do that. One, I think, anecdote that points to the significance around the time frame is an individual who testified in House Judiciary who had this requirement for 3 years and was, I think, at 2.5 years in the point of paying for the insurance when she hit a rough financial spot and missed a payment. And then she had to restart with the 3-year time frame. So the cost, which I understand is both driven by people's driving record, but also the additional fact of having to have this certificate submitted to the department, which proves you have insurance, really is a burden and an onerous for many people. And the bulk of people with whom we're working through in diversion are low income and frankly don't have their license because of financial struggles they're facing. So in a nutshell, the Attorney General's office would appreciate the passage of this legislation and see that it would benefit a number of Vermonters with whom we're working who are trying to regain their driving license.
Okay. Questions for Willa? Thanks very much. Good luck with the airbag.
Thanks very much, Senator Sears.
On to James Feenan, lobbyist for the American Property and Casualty Insurance Association.
Morning, Senator Sears, members of the committee. Thanks for having me this morning. Jamie Feenan with Primer, Piper, Eggleston, and Kramer on behalf of, as you say, the American Property Casualty Insurance Association. It's a national trade association of more than 1,000 members, both national companies and local companies, several hundred of whom are licensed to operate in Vermont, including a number of auto insurance companies that you'd be familiar with. I'll speak to the, since you're deleting the first section, I didn't have any comments on that in any event, but it is obviously the SR22 amendments in section 2 of the bill, and also the reduction of time period to maintain the SR22s from 3 year to 1 year. And as you've heard just now, and as I heard some of the testimony in the other chamber, I believe my understanding of this bill is motivated in part from the impact of requiring the SR22 has on certain populations and the ability to remain licensed drivers. Senator Sears, to your earlier point and sort of teed up the question, it probably may be helpful for just a little bit of a background on insurance underwriting. They consider a number of factors, including an insurer's operating record, their violations, the number of those violations, the severity of the violations, and then other factors such as the make and model of the vehicle, miles driven, purpose. All of these are sort of considered as a whole, and the insurer then tries to establish a premium that matches the risk of that insured individual. It's becoming quite accurate these days, and I think it's beneficial as whole because the risk is rightfully priced for those who are riskier drivers, while those that or don't have that risk enjoy better premiums and aren't necessarily subsidizing those that are, like myself, riskier on the roads. So, for those with a poor driving record who continue to incur violations, they become less and less attractive to insurance companies as a risk. They may, for example, be moved from a premier company to another company, or an insurance company may say, that risk is just something that we can't bear anymore. But nevertheless, there's a market for insurance, whether it's through, as I say, affiliated or subsidiary companies, or even in the secondary market. And in this particular instance, there is definitely a market for individuals looking, who have SR22s and are looking for insurance. Some companies even specialize in this area. All things being equal, a driver with a poor, as I mentioned, with an individual with a poor driving record is going to pay more for their premium than someone without. Someone required to have an SR22 is likely to pay more for that than someone without. And so, as I say, the company tries to have their premium reflect the risk of the individual. For APCIA, in looking at the bill, the proposal to remove as a requirement to maintain an SR22, the operating without financial responsibility, in other words, operating without insurance, gives us the most concern, and we'd prefer that it not be deleted, that it remain as is in a violation that would require maintaining an SR22. As this committee knows, Vermont, like virtually all other states, is a mandatory state for insurance. The law requires that an individual have and maintain auto insurance, with the public policy position being that all in is good public policy. Vermont's uninsured motorist rate back around, I think when the House was looking at this in March or so, was at or close to 6.8%, which compares favorably to the national average of 13%, though it's a number that can fluctuate from year to year. Keeping that number of uninsured drivers down helps all of us. It keeps the number of uninsured motorist claims down, premiums down, et cetera. We look at SR22s as an enforcement mechanism for unlicensed drivers. It's possible that by eliminating this requirement under F to maintain insurance, that we may see an increase in people driving without insurance. One could argue that, most Vermont drivers are law-abiding citizens and enforcement mechanisms are not needed. However, not everybody falls in that. And the mere nature of 6.8% uninsured means that one out of every 15 will drive without complying with the law. So, we look at the SR22 in this instance as a way for companies to accurately rate to the risk, and removing that designation means that those that follow the law and those that don't, those that follow the law will could bear the impact of those that aren't. Your predecessors obviously felt that, this was an offense that was worthy of maintaining an SR22 as an enforcement mechanism. I don't have numbers. Maybe DMV might be better in terms of, the total number of SR22s that are issued, the numbers that may lapse, how many need to get another SR22. But it may be interesting if there is that information, to see if it has been a successful, enforcement mechanism while it's been in place. Obviously the question in front of you is one of balancing public policy. Is it worth the potential result on uninsured motorist numbers and premiums to provide this benefit, I guess, to certain populations looking to climb out of some financial burdens they may be facing. We do look at the amendment later that reduces the time frame to maintain the SR22 from 3 years to 1 year, and think, maybe that may be a better first step with respect to this provision requiring auto insurance. If it is financially hard over 3 years, maybe the 1 year will provide that benefit, but still maintain the requirement to have insurance as a requirement to have an SR22. Just some food for thought. Happy to answer some questions that folks may have, but appreciate the time this morning.
I'm hearing from you that insurance rates may not change for people who, even though on year 2, they'll no longer be required to have an SR22, they may still pay a fairly high premium based upon their own individual driving record. Is that correct?
That's a fair characterization. Again, as you, as an individual incurs more and more violations, insurance companies take note of that and likely adjust premiums to reflect that.
So somebody who, went out on the campaign trail and said, I've lowered insurance premiums, may not necessarily be accurate. I've lowered insurance premiums for, I've lowered insurance premiums for high risk drivers. May not be accurate.
Well, I think what the bill is trying to do, as you heard from the previous witness, is remove some of that financial burden that begins to mount and compound over time, whether it's, the 3-year period or whether or not it's, the requirement to maintain the SR22 itself. The SR22 itself is not expensive. It's, $25 maybe, I think is something I've heard. It's the insurance that probably gets to be more expensive. Once you fall into that category, it may be more expensive than folks are anticipating.
Your big concern with this bill is eliminating the ability to the requirement for financial responsibility.
Right. We think
that would be
again,
page 3F.
Page 3F, correct.
Yep.
We think
Section
that's
3F.
an important enforcement mechanism, and Vermont is a mandatory state, as I mentioned. And, these SR22s are for, as you've seen, I think someone talked about getting an SR22 for an accident. That's not necessary. These are for, theft, for example, DUI, egregious offenses. And at some point, your predecessors, I mentioned, felt that maintaining insurance was on par with that.
No, I just wanted to be clear what exactly. You don't necessarily oppose the reduction of the SR22 from 3 to 1 year for many drivers.
No, as I mentioned, I think that's maybe a better start, at least with respect to maintaining the auto insurance, to see how that works and maybe take a look in a couple of years to see if that has helped through some of these anecdotal stories.
Okay, so when we get to markup, I guess that'll be one of the questions for the committee, is whether you want to delete section 3F on page 3. Any questions for Jamie? Very helpful, as always. Appreciate it. Judge Grierson, welcome back.
Thank you. It's
welcome
good
to session 3.
Yeah, good to see everyone.
Yeah.
For the record, Brian Grierson, Chief Superior Judge, and I think the only section of this bill, Senator, that had any impact on the judiciary was section 1, which you've now removed. The rest of it is strictly motor vehicles and motor vehicle requirements. So I think that's the extent of my testimony, unless you have any questions.
Wow, I hated to keep you waiting all that time.
That's all right. I was listening to the comments. It's fine.
Any questions for the judge? All right.
And I will see you in another session, I'm sure, this week. Thank you.
I think we'll see you tomorrow.
Yes. Yep.
Okay.
Thank you.
Committee, I would normally say let's mark up the bill. And if you want to tentatively mark it up now, we could. But one of the things I'm waiting is tomorrow, Eric is walking us through another bill, but also will walk us through the House changes to the DLS bill that we made on driving with license suspended, if you remember. Our effort to have some days where we would be able to waive the form of fines and other things to get people where it's a monetary consideration to get their licenses back following a suspension for failure to pay a fine. You remember that bill we did? No? Yeah, we passed the bill. The House has taken it up and made changes to it, and I thought we should go over the changes. Yeah, because they relate to the license suspension. But if you want to work on marking this up, or you want to wait, take the rest of the morning off, it's up to you all.
Are you thinking of combining the bills? Is that what you're,
No, I wanted to make sure that before we pass H578 out of committee, I wanted to make sure that we were in agreement with changes that the House is contemplating on our bill that would provide for, I guess I'm going to refer to them as license suspension holidays. Remember, several states' attorneys held times when people could come and they would waive the traffic fines that were unpaid and any interest and other obligations.
yeah,
That was the idea behind that bill, was to have another statewide. I believe it was going to be in August of this year, but obviously that'll change. But
mhm.
we passed that early in the session,
Yeah, I do remember it now.
and they're taking it up.
Yeah. Oh. We can wait and do them both, whatever anybody wants.
Yeah, well, we need to decide to concur or not concur with their changes. So I thought it'd be a good idea to know what they're contemplating.
Yeah.
I believe Eric's doing that bill. Am I correct?
Yeah, I believe that's in S234, section 28, which was the miscellaneous
Yes, right.
judiciary bill.
Miscellaneous judiciary. Yeah.
So section 28 is persons with suspended driver's licenses amnesty program. And it would have required the Department of Motor Vehicles to do something on or before September 1 of 2020. So
Right.
it was something you passed a while ago. And I believe it is in-house judiciary.
Okay.
Okay.
It is in-house judiciary.
As far as this bill, if you could just prepare with the dates that we talked about with the department.
Yep.
And then committee's pleasure on section 3F.
Yeah.
That's the one that repeals the requirement for operating without financial responsibilities as being a suspendable.
Mhm.
So it's in section 2 at the top of page 3, the repeal of 801A1F. The third line on page 3, whether or not you want to repeal that or not.
I don't know.
Could you just explain what would happen if we don't repeal it?
If you don't repeal that, you would continue to require the SR 22 if someone was convicted of operating without financial responsibility. And then with the changes being made in section 3 to 809, because you're changing the general is 1 year, and then there are exceptions for 3 years. If someone was convicted of operating without financial responsibility, they would need to have the SR 22 for the 1 year from those different counting points.
Okay.
So that if you take out the repeal of subdivision F, it would require people convicted of operating without financial responsibility to carry the SR 22 for 1 year, provided that you don't make any other changes to section.
Right. And if we do repeal it, they're still required to have financial responsibility, correct?
They're required to have financial responsibility. They're required to have insurance. They're just not required to have that SR 22.
Right. So it's more likely that they would buy insurance than if they were required to have an SR 22 in my mind. That makes sense? Senator Bruce?
Um, I'm trying to simplify this a little bit in my mind. It seems to me that if somebody has been driving without insurance, then we require the SR22, which puts them into an elevated premium
Right.
category. We intensify their financial problem with driving. So if that's correct, which is how I understood the insurance perspective, when they say rate to the risk, they mean raising that person's premium. So I like it as passed by the House, because they're required to have insurance, but they're not going to have to pay an elevated premium to get it.
Great.
Yeah.
Yes, Senator White.
So I think I agree with Philip. I thought what I heard Jamie say is that with or without the SR22, if they have, that they're going to be rated on the risk, so their insurance might go up anyway.
But probably not as much.
Right, but probably not as much as with the SR requirement of the SR22, although I thought what I heard him say is that it itself is relatively inexpensive. It just puts you in a higher category and you might go into that higher category anyway. So I don't know. I might have misheard what Jamie said.
I'd say at this point, just for markup purposes, we could do a bill changing the dates and striking section 1. That we don't need to do a strike all. And if you could have that for tomorrow morning, maybe we could vote this out of here. If you're available tomorrow, if that's enough time.
I believe I am. I just need to check when House Transportation is not meeting tomorrow. I am available.
Great.
I just asked a question.
Yep.
So I'm just thinking with what Jeanette and Philip just said, and I'm just wondering, if you're required to have insurance now, so that's not changing. So now you get stopped and you don't have it, and there's no SR22 going into place. Why would you bother getting insurance? I mean, if you get stopped a second time without insurance, does that make any difference? If you get
No,
stopped
you can
time?
have your license suspended if you don't have insurance. This doesn't change that. My understanding is all this does is says if you're driving without insurance, it's not an SR22 offense. And then, so you don't have to get into that higher category. You still have to get insurance. And if you don't have insurance, it's still suspendable. And I believe you can't register a vehicle if you don't have insurance.
Well, I guess what wasn't the issue, you get it registered, then you cancel the insurance, or does that trigger
Well, I
some
know, but
DMV that alerts them?
you're still required to have insurance, but
Yes.
and if you don't have insurance, it's a suspendable offense if you get caught without it. This just says if you get your license suspended, you don't have to go into the SR22 category
Okay,
for driving with license suspended, and perhaps you would have a more
Yep.
reasonable rate and be more likely to be able to afford the insurance
okay,
if you had an SR22 category.
okay.
That's my understanding of it. So Peggy, would you just adjust the agenda to have us mark this up at, say, 11 tomorrow?
Will do.
Okay, thank you very much.
Can I ask a question?
Yeah,
before,
sure.
before we go, that doesn't have anything to do with this issue, if we're done with this?
Yep.
What did we do about bail? We changed it to minimum of 200, a 200 bail, right?
Mm-hmm.
From 1,000, which really screwed up things from what I understand, but
Some people might think that.
well, I thought that the problem was that before the minimum was 200 and now the bail bondsman won't do anything less than 1,000. So now they're paying 200, where before they would have paid 100. But anyway, we don't have anything going for removing bail, do we? For
No.
eliminating it?
Not this third session, no, but we
Okay.
could get an update from Eric, Michelle, or Bryn. I can't remember who did the bail bill. And the Attorney General's office and the state's attorneys and the Defender General. I know there will be continued efforts, whoever's here in the next session, to deal with bail. The problem doesn't go away.
No, I just wondered because I have a group down here, a church group that's working on that issue, and they asked me to tell them where we were with it, and I couldn't remember.
Well, we did pass a bail bill.
Mhm.
We tried to lower the amount, we try to, and Judge Grierson may also, somebody else may also be able to answer the questions, but I think, and Joe maybe knows, but I think that it's reduced the number of people incarcerated on bail, that people are now being released if it's a small bail. If they're violent, I suspect they're still being held with bail conditions.
Joe, do you remember? Because what I remember was that we changed it to 200 instead of 1,000.
Right,
for-
the
whether that
Department of State's attorneys, I believe that the Defender General recommended 0. The
Mhm.
Department of State's attorneys wanted 1,000, and we settled on 200.
And that what happened as a result of that was where people used to be able to go to a bail bondsman for, if they had $1,000 bail, they could then pay the $100. But now the bail bondsman won't take a $200 bail. So now they're paying 200 instead of 100. Do I remember that right, Joe?
I think your memory about what happened is correct, but if you're asking for anecdotal evidence about what's actually going on, I couldn't tell you other than to say it appears to me that at least judges in my neck of the woods are less and less reluctant to impose bail. Much to my surprise, some people are getting out that I normally would have seen bail imposed upon, and they're being released on their own recognizance with specific conditions, but it's too early for me to give you an accurate picture other than those anecdotal situations that I'm directly involved in.
Okay, thanks.
Dick, can we talk about logistics?
Sure.
I don't know what your schedule is going to look like in the next 3 weeks, but Wednesday mornings, it's tough for me to get here at 9:30. I can be here at 10 without a problem, probably
Okay, we could
quarter
go
of.
10 to 12 then.
It would be much
Instead
easier
of
for me to
9:30
do
to,
that.
instead of 9:30 to 11:30, is everybody okay with
Yes,
10 to 12?
yes.
Yes.
Next week, we meet on Tuesday with House Judiciary and House Government Ops on the use of force. On Wednesday, Peggy, we can change this to 10 to 12 instead of 9:30 to 11:30.
Okay,
And Thursday, and I plan to do some budget work. We need to look at the corrections budget, the Woodside budget, which is a mess, and the judiciary budget. I thought we would do that. And the public safety budget. Want to really look at public safety because of all the discussions about changes and, in policing and so forth, and also what they've recommended in terms of the body cameras and how they're doing on that. And also, obviously, I believe they're now talking about having social workers in most barracks.
We also asked, because law enforcement is in our area, we also asked Mike Sherling to come in and talk about the budget in DPS.
Well, maybe we don't need to.
Well, we'll see I don't know that we'll have time on Friday because we're looking at the Human Rights Commission and all those kind of commissions and stuff at their budget. And then we'll go to DPS if we have time. Otherwise, we'll do it on Tuesday.
Well, I mean, there's no need to put them through 3 budget hearings.
Oh,
Well, I didn't realize you were looking at DPS's budget.
I don't know. Jane just said, look at areas where that fall in your jurisdiction. And since we do
I
law,
know, but
Yeah.
I realize the Government Operations Committee has tremendous authority over tremendous
Everything.
array of subjects.
everything.
I kind of think,
We're looking at AOE too next week.
They need everybody looking at them. Joe, you need to have them in too.
are you going to have higher education too?
No, we don't want them.
That might be controversial. Seriously though, I will rethink that because
Okay,
my part of my job and on appropriations is the DPS budget, so I'll be looking at it individually anyway, but
okay. So the other question that came up,
if you're really gonna have them in, then
well, I sent them an invitation and he's responded back and said, thank you, we'll be there. That's, so we can talk about this later, but, and the other question that came up was those kind of independent offices out there and their budgets, who looks at the AG's office? Would that be Judiciary, I think, but we weren't
yeah,
sure.
I do the, on the Senate Judiciary Committee, I Senate Appropriations, I do the AG's budget, the DG's budget, the public safety, corrections, Woodside, all those things. Do you know who's looking at the sheriffs?
We are.
Maybe we should look at that too, Peggy. I want to, it's part of Woodside because Sheriff Marcoux is taking kids that would otherwise, Woodside stopped at taking applicants, taking admissions, stopped admissions, as I understand it. Now they're being supervised by Lamoille County Sheriff's Office.
Well, you mean looking at their budget?
Yeah.
Because most of their budget doesn't come from us anyway.
Well, but if you look at Doug Hoffer's analysis of police costs in Vermont, it's an astounding number.
It is.
If you just focus on, I mean, it's time we looked at sheriffs.
Yeah, but I'm not sure that just looking at their budget and their statutory responsibilities, we've been looking at how to change their statutory responsibilities and along with the whole law enforcement issue. But most of their budget, the only things of their budget that come from us are the sheriff's salary and the 2 transports.
Well, maybe,
So,
but what, but they are law enforcement. They have contracts. They are, and they are private businesses too.
I know
And
that.
I think that we should look at law enforcement holistically in the state.
That's what we're doing.
Well, we're not, because
No.
you're looking only at what the state's requiring.
No. What I'm saying is that.
Are we looking at local police expenses too?
No, the whole issue of law enforcement is something that we're looking at. We've been looking at it for the last 2 years, but the budget, when Jane asked us to look at the budget for local law enforcement and for sheriff's office is not within our jurisdiction. So unless we're looking at it as a whole, the way it's organized as a whole and looking at that, then we start looking at the money. But we can't tell the counties what to pay or not to pay and whether they should have this issue is far beyond a week's discussion.
Understood, but at some point, if you're going to deal with, and I don't believe in defunding law enforcement, by the way, which is
No, I don't.
one of my opponents evidently thinks I do, or has put that in his mouth. But I do think we have to realign what law enforcement does And it
Yes,
starts with the entire state. It isn't just the state police, which
No.
we have budgetary control over. It's the sheriffs, it's local departments, it's constables, it's anybody who's working in law enforcement in this state. It has to be looked at low, you know.
that's what I'm saying that we've been doing for the last 4 years and we continue to do it.
Well,
124,
but it's getting us, if you look at Doug Hopper's figures, that's all I wanted to point out.
yes,
In terms of a budget, when you look at Doug's figures, we spend a lot more on public safety than anybody realizes in this state.
yes, we do.
So we should start to look at it. I'm not suggesting we do it next week. I'm suggesting that we keep it in mind as a goal and not to defend each department. Maybe even if you think we don't control, there's a lot of things around the country going on with sheriff's departments.
So if I can just make one last comment here. We have been, for the last 4 years, starting with when, oh no, maybe Joe wasn't on the committee. We have gone to lots of communities around to talk about law enforcement, how it's organized, the access to it, how it's funded, the unequal access and unequal funding. And we have been working on that for a long time. 120, we did many changes last year and the year before, and 124 is an outgrowth of that. We continue that conversation and we continue looking at the studies that have been done in the past about how we should maybe reorganize. And we continue working with DPS, the police chiefs and the association and the police association and the sheriff's association. All of those together are coming into our committee regularly to talk about how we look at law enforcement in the state.
I'm not blaming you for this.
No.
I'm suggesting that we need to look at holistically
That's
the
what
money
I'm
that
saying
we're
we're doing.
spending and the money that Vermonters are spending. It's their tax dollars. And whether it's a local police department, a county sheriff's department, or the Vermont State Police, or the Vermont Fish and Wildlife
Yes,
officers,
they
all
come
of them
in too.
together, all law enforcement together.
Yes,
We need to stop looking at it in silos and looking at it together and to the results.
that's what I'm saying that we're doing. That's
Can I
what we're
suggest
doing.
Not
something?
doing that though.
Right.
Yeah.
We are doing it.
Okay, hang on. I just want to suggest you guys are talking past each other. And the reason is that I think what Dick is saying, when he says we need to look at it, he means we need to look at it, I think, and achieve cuts or efficiencies. Jeanette is saying she is looking at it holistically, but have not seen the need, I don't think thus far, to make cuts.
No, I'm not saying that. I'm
Okay,
not saying that at all. I'm saying,
what are you saying?
what I'm saying is that the way we provide law enforcement in Vermont is a very, it's complicated and it doesn't make any sense. And what we have to look at is we have to look at it holistically about how we supply it and how we fund it. If we funded it differently, there may be cuts there. We're not looking for cuts. What we're looking for is how do we organize it and how do we provide law enforcement to the state of Vermont in a better manner than we do now. And I'm not saying we're not looking for cuts because we could be, but that's not our prime goal. Our prime goal is to provide law enforcement in a better manner than we do it now. And we're not looking at it in silos. We're looking at it holistically. And I mean, we've been doing this for 3 years, and if we're doing it wrong, then somebody else can take over. But we've been doing this for 4 years. We have 2 years ago, we heard from about 400 to 500 people in the state in public hearings that we went around the state. So we've been doing it. And those law enforcement people are in our committee all the time. So I don't know what else we should do.
Philip is partially right. I was talking over you and we are actually saying somewhat of the same things. I'm just suggesting that as we look at what our police department's doing, how did we end up with police departments with armored vehicles? How did we end up with,
We have 2 in the state.
well, then we have too many in my view. How did we end up with where we are at? And what can we do better to make sure that we're policing for the future? And given the problems that we've heard about, particularly from persons of color and other minority groups. I mean, there's an interesting going on. The sheriff in Addison, if you want to remove our counties, the sheriff in Addison County is accusing the chief of the Virginia's police department of corruption.
Yep.
And then you've got the sheriff in Caledonia County, who's been sheriff's deputy, who's been accused of certain sex acts. And then we've got the sheriff in Bennington County, who was accused of certain inappropriate texts and other things to people. You've got cases all over the state where you're looking at this disjointed law enforcement conundrum. So I'm just, and then you've got the 14 states attorneys with different views of justice, and who they prosecute and how they deal with it and all that. So it's not just the local law enforcement, it's states attorneys, it's the entire criminal justice system. And who gets blamed? Corrections.
Hey, Alice, shifting gears,
Yes,
judicial retention.
I'm sending ESP messages to you left and right while I'm sitting here looking at you. I have a thought to judicial retention. I feel absolutely has to happen this session while we're here right now, because otherwise it's done. And I think that, cases are vulnerable to getting kicked out. So I'm thinking.
Well, I'm ready to go with my report whenever you tell me we're going to have.
Okay, so I'm thinking that John Bloomer had some ideas previously, and I think if we ask John and Eric to work together with Mitzi and Tim to get this thing scheduled somehow. I think that given that Mitzi can operate a zillion screens, I think that, and I just saw another email regarding something else where maybe they could add people on, or John had an idea with regard to mailing some things out and then doing it. So I think it absolutely has to happen.
Okay.
So.
Okay, I hope it does. I would agree with you, Alice, that it could be risky to not hold any retention vote.
Right.
In 2020. For those, how many judges do you have?
6? Do we have 6, Joe? I can't remember.
Yeah, I think it is 6.
6.
Somebody needs to get in touch with Condos on how you'd provide a secure private vote, though.
Okay, well, I think if John and Eric.
Unless we change the rules, because.
Well, I think that's what John Bloomer was thinking of, a way to do it with a private vote. So I'll check in with him and Eric and see what they could propose with regard to a private vote before we try to change the rules.
Yeah, because once you've established that it's going to be a public vote, then.
Yeah. Yeah, that's right. Okay, I'll see. Go ahead, Philip.
Philip?
Yeah. If we're
just
switching around to other topics,
yep.
is there any movement on the conference committee for tax and regulate?
There is tremendous agreement on a number of areas of the bill. I could be corrected by Senator Benning or Senator White.
Don't forget we're on YouTube.
We have acceded to the House in about 25 areas
We are on YouTube.
that are,
remember?
I know, that
Okay.
are, I remember that. Thank you
Okay.
for reminding me. We've acceded to the House in many areas where it's mainly wordsmithing and they've changed words that we used and a few dates. And obviously, we passed our bill on March 1st, 2019, and they were still in conference in 2020. So there's a number of time frame changes. We've agreed to a lot of things. I would say we're down to about 8 issues, one of which is mandatory seatbelts, one of which is saliva, one of which is, help me here, Joe or Jeanette.
Local options tax,
Local options, opt in, opt out.
Opt in, opt out.
prohibited.
Prohibited
products.
advertising. They had a floor amendment that prohibited advertising. We see that as a constitutional issue. And we had a section on product safety that they want improved on, but that I don't think we're necessary disagreement. There's another disagreement on revenue uses, and they have 30% of the revenue from the 14% excise tax going to the substance misuse, for substance misuse as recommended by the council. And I think we've come down to where we on the Senate side are not necessarily objecting to having that 30% figure, but we are concerned that a group that's not, the legislature is making decisions about where the money's spent. And that we'd rather have the appropriations and the administration making decisions of that nature. And then they have a 6% sales tax, and that is dedicated to is it after school and preschool programs, Joe?
Yeah, I think so.
So I don't know, and you may want to look at that actually and give us some advice on that section. But that's what we're down to. And I would say we've been pretty clear. If they don't give up the seatbelt idea, we've said even if the 3 of us agreed with their primary seatbelt, which we don't, there's no way we get it through the Senate.
And I'm not sure that all of the House is firmly behind that, having that in there anyway.
Well, I think we've determined that the speaker put it in, or asked to have it put in, and the Government Operations Committee put it in.
It just seems too bad that the thing would founder over something unrelated to the policy at hand. I
Yep.
mean, you can claim that it's highway safety, but you might as well have,
A helmet bill.
right, whatever,
I mean, at least the saliva issue is
Yeah.
somewhat related to we don't agree with it, but it's somewhat related to the issue. But the seatbelt issue has no relationship.
Yeah.
I don't get
No,
it.
and also in this age where we're talking about people being stopped, persons of color and other minority groups being stopped at higher rates, this just gives one more, and Joe actually eloquently stated that to the.
It's another opportunity for the police to pull somebody over. And in this day and age, when you're having these discussions about Black Lives Matter and why they're being pulled over at a rate that's different than white people, you just do not want to open another door for police to be able to pull somebody over. And unfortunately, this has been a hang up. But Philip, to answer your question logistically, we have made a pitch to the House. The House is coming back to us. We're scheduled for Monday morning for another, I think, 3-hour session of trying to hash out our differences.
I'm going to say the good news is the Zoom worked. We
Yeah.
actually are able to do breakout rooms where the 3 of us can go with Ledge Council. Peggy and others at Ledge Council have done a tremendous job of setting it up. Both sides can go to their own individual Zoom meeting rooms. We were allowed to bring in, like we brought in Chris Pearson because he's on finance and has been taken an interest in the taxing issues. So we've met with Joe, myself, Michelle, and Chris Pearson and Jeanette in private rooms, and it really worked. So if I was a little concerned about how a conference committee could work, and it's worked well. I will say that. So if any of you end up wanting to have a conference committee on your other committees, it can work.
Mhm.
I mean, I don't know, Jeanette and Joe, if you felt the same way, but I was very hesitant to do a conference committee on Zoom.
Yeah, I was too. And I think I was impressed the way it worked. We just like, they just slid us from one to the other and then slid us back. And it was all, and the sessions, the individual sessions didn't go out on YouTube. It was just, that was suspended for that.
The
period of
breakout
time. We
sessions.
went back. It was really, they did an amazing job, I think.
Yep, their staff deserves a whole lot of credit for that.
Would you make that message to everybody, Peggy, please?
Will do.
Thank you. Is there anything else anybody wants to talk about? If not, we'll see you tomorrow morning at 9:30. Thursdays is okay at 9:30, Joe?
Yeah.
Okay. See you all tomorrow morning at 9:30. Have a
Oh,
good
no,
night.
Be at 1 o'clock, aren't
it's
you?
1 o'clock.
Why?
Oh,
What are
on
we
the
doing?
floor.
We got Senate on the floor.
Oh, darn.
What are we doing? Anything?
I don't think there's anything. Tim actually said yesterday in a probe said we could be done in 5 minutes.
Why not just make it a,
Token? I
Well,
don't know.
we're reassembling for the point of response arguments on points of personal privilege.
I forgot to ask for journalizing some of those remarks.
well, I don't know if you guys have seen the new 7 Days.
No.
There's an article about the Northeast Kingdom Senate race, and it gives some context, I think, for what we saw yesterday. So
Oh,
I'll
interesting.
just put it that way.
Well, I asked Bobby why he didn't move to journalize.
Wow. All right.
Have a good day.
Something tells me the district lines are going to be redrawn in an interesting way here in the kingdom.
I got a feeling. It's like the time, I got to tell a quick story. When years ago, when Jim Condos represented Chittenden County, and there was a special committee on the redistricting, and they threatened Jim with putting South Burlington into Bennington County with a big circle down Route 7. He was chair
All right.
government ops at the time. All right, have a great one. Thank you.
See you at 1.
See you at 1. Bye.
Bye-bye.